Pat Pattinson is a professional turnaround practitioner specializing in the rehabilitation of distressed businesses with a success rate of more than 95% for all business rescue plans published to date. Pat's commitment to the practice of compliant and ethical turnaround practices is rooted in his passion for saving businesses, saving jobs, and providing the best possible outcome to all affected persons. The restructuring or rehabilitation of a distressed business is one of the toughest things someone can go through, and is often a process filled with more confusion and frustration than is truly necessary. And that's why Pat created this series of turnaround boot camps. The more people know about at least the basics of restructuring or rehabilitating businesses in distress, the more clarity they can bring to the process. This is only one episode in the series of boot camps. Be sure to follow Pat on LinkedIn so you can receive notifications of when registrations open for the next one.
Good morning, everyone. And in our next session, Financial Distress, Laws Directors Must Know, we will cover some of the most basic laws that directors should know in financial distress that I have come across in my career as a turnaround practitioner. It's obviously just a very short selection of these laws. There are substantially more of them out there, but we will unfortunately not have sufficient time to go through all of them this morning. Before we can go into the laws, just a quick recap of the previous episode, just to understand again what reasonable distress is. What financial distress is. Financial distress is contained in our Companies Act in section 128F. It then provides us with a definition that states any company that finds themselves in a position where they cannot pay their debts as and when they become due and payable. Alternatively, if that company is going to become insolvent in the next ensuing 6 months. That's the basic definition. The recap that's really important is what are directors supposed to do when they enter into financial distress. And that is, of course, contained in section 129(1), where it states that a board may elect to place a company into business rescue when they realize it is in financial distress. A second part to that same definition is that if the board of directors decide not to put the company into business rescue, not to go for liquidation, they have to provide a formal notice in terms of a CIPC downloaded COR document explaining why they have made the decision not to go into business rescue. So the two highlights, the two important aspects of this is that the Companies Act is very clear what a board of directors must do when they realize a company is in financial distress. File for business rescue or send out the notice. Now, we also know that directors have got benefits when they are employed, better salaries, they are in charge, they run the entities, they get to make the decision. But what a lot of people, including most directors, don't realize is the Companies Act also governs certain responsibilities upon directors. Directorship is a position that you choose to fill. You choose to become a director. It might be for various reasons. You might be the founder of the company. You've decided to remain a director, or you have been promoted to a director, but ultimately it remains a choice. And Section 76(3) puts responsibility on those people who have decided to act as directors, that they must act in good faith for the proper purpose of the business, in the best interest of the company, and not for any individual, not for them personally, but in the best interest of the company. If they do not, if they fail in their fiduciary duties as a director, Section 162 of the Companies Act provides that they might be declared a delinquent. That is an application that's done to court. It's a very difficult process, but once it is successful, it has severe repercussions on directors. Those same repercussions, perhaps not to the same extent, remain there for those who have simply been part of such an application. The mere fact that you as a director have been placed in a position where there is an application to have you declared a delinquent can do substantial damage to you in your personal capacity, to your business, and of course, the future that you may or may not have with that particular company. Now, previously, only certain individuals directly connected to the company were able to put an application for delinquency against a director. Those were shareholders of the business, fellow directors, the secretary or the prescribed officer of the company, registered trade unions, or anybody that really represented the staff may have applied to court to have a delinquent director declared a delinquent. Recently, that was changed, and it was now even possible for creditors in a business rescue process, or possibly creditors in general, to have this application done against a director to have him declared a delinquent. So, in what instances can a director be declared a delinquent? Again, it's not just something that if you wake up in a bad mood one morning, or if a company owes you money, that you can frivolously go after the directors. There are certain conditions where this is applicable. Most commonly known as those contained in section 77.2, where there's a breach of duty and it caused any loss of damage. In addition to that, a director could then, in those instances, not just be held liable or be accused of being a delinquent. They could be held personally liable for any damages, any loss, or any fault suffered by any other person. Now, 77.2 is very important, or 77 in general is very important, and it's in contrast, but in support of Section 2182, which we will touch on now as well. Section 77 allows a director to be liable to the company, not to the creditors or to anybody else, but to the company. But in my experience, and it has happened in the past in a very roundabout way, where the creditors holds the directors liable in terms of 77, the director then pays the company, and the funds that goes into the company can then in turn be used to settle the creditors. So it is not just an internal process, different to delinquency again. But 77 requires that there must be a loss, there had to have been damages, and there have to have been a cost incurred. It must be a tangible. It's not like in the American courts where you can simply sue and get massive settlements because you've suffered an emotional loss. It has to be a tangible loss. And that specific director must be liable as a result of a decision that he has made, either in his capacity as a director acting on his own, as part of the board of directors, or where he didn't act appropriately when a vote was called for in any other matter in a board meeting. If we look at the risk of Section 2182 in comparison to that of Section 77, this is a lot broader. It is also a lot simpler to prove. And it simply states that any person that has suffered a loss as a result of any other person contravening any of the act may be held personally liable for any losses suffered by that person. So it's no longer a case where the director is liable to the company. This could be by any person, staff member, creditor, even a customer that has suffered a loss as a contravention of the act. So in this instance, again, what's a little different to 77, you had to have proven that the director did not act in good faith and that there was a loss as a result of that. Here, the loss is then from any person, from any other person. But as previously mentioned, this is not just something that can be done frivolously. It cannot be done to victimize. And one of the concepts, one of the theories that is used to test whether a director, or in terms of 2182, any person is liable, is the reasonable person test. And this is a test where a hypothetical person who is in the same position as the director or the other person that have made the decision, that has the knowledge that that director is supposed to have. It is not knowledge that he does have. When you assume the position of a director, certain results are there. You have to accept certain responsibilities, and you are supposed to be knowledgeable in certain areas. So if this hypothetical person would have made different decisions placed into that same position that that director was placed, if there's called for a vote or there's called for a certain decision to be made, and it can be found that a reasonable person would not have acted as that particular director acted in that specific situation, that is one of the motivating factors to hold a person liable, either in 77 or in terms of Section 2182. Some of the other contraventions that we can look at, over and above the conditions as set out in Section 129, 1 and 7, is of course in Section 22. Now, again, ladies and gentlemen, I'm limiting the examples to matters that I've come across in the past and that are applicable to financial distress. Section 22 of the Companies Act states that a company must not act recklessly, carry on its business with gross negligence, or with the intent to defraud. Now, in the most simple terms, to continue trading in financial distress circumstances, knowing that it is possible for you not to be in a position to pay people for whom you have asked to provide services products, that is, of course, grossly negligent. But at the same time, it could also be said that you acted with the intent to defraud. And again, ladies and gentlemen, this is at a stretch, but I have had it in the past, where the creditor simply stated you knew that the company was in financial distress, you knew that you couldn't pay your historic debt, yet you continued to give me orders, I continued to supply, and you knew you couldn't pay me. Therefore, you misled me and you intended to defraud me from the payments that was duly mine whilst the company was acting in financial distress. There are also an amendment to the Companies Act that have been suggested for Section 22. That would be in Section 22(1)(b), which then defines it even more, that a company is not permitted to act under insolvent circumstances. Now, if you go back to the definition of financially distressed in terms of Section 128F, it says that any company where it is likely to become insolvent in the next ensuing 6 months is in financial distress. So although not directly linked, the definition is definitely part of it. So if the company continues to trading in insolvent circumstances, which in turn would be financial distress, the directors could be held liable in the various sections. Ladies and gentlemen, as I said, there are many, many other examples, but one of the examples that come across most often is a contravention of Section 45 of the Companies Act. Section 45 governs the extension of assistance to connected entities. In other words, all the directors' loans or loans to connected companies, family members, and it doesn't have to be purely financial. It could be standing as a guarantee. Any of those financial assistance must be governed through a certain set of rules before they can be extended. The most basic of those is that there must be a meeting held by the directors. A solvency and liquidity test must be done as to what the company's position would be immediately after that loan was to be extended. There are other conditions, but that's the one we're going to talk about this morning. Now, in previous episode, we spoke about zombie companies and how certain directors would start relying on loan accounts. They would not take a salary, but they would rather take a loan, which means that they do not have to pay as you earn and some of the other taxes associated with that. Problem being, not necessarily for the companies that are trading in solvent circumstances, not to those that can pay their debt as and when it becomes due, although it remains a contravention of the Act. The loss that we are talking about here materializes when the company goes into business rescue or ultimately liquidation. It is often said that no one has been held liable in a business rescue. The simple reason for that is that the majority of these business rescue converts to a liquidation because of the inability to be rehabilitated. In that liquidation, or in most instances in the business rescue, the business rescue practitioner or the liquidator, or if it is a sequestration, the trustee will then go after these loan accounts. And in some instances, there's an inability for these loan accounts to be settled because certain tests was not done. It was reckless lending, reckless borrowing. In those instances, if Section 45 was not adhered to, those that were part of extending this loan, those directors could be held liable for those loans because of the contravention of that particular act. Now, again, Section 45 is just one of those. There are substantially more, but we would need a lot more time to go through that. Other sections that directors must be aware of is in the Tax Administration Act, We've done a little bit of the Companies Act, jumping to the Tax Administration Act. And again, there is a lot of these laws the directors would know, but the one that I want to point out today is Section 234 of the Tax Administration Act. Now, the Tax Administration Act makes it very clear, and especially in Section 234 and 237, of certain contraventions that could happen in a company. Those contraventions are things like not submitting your VAT returns on time, not submitting them at all, or fraudulently submitting them. It is to appoint certain directors. It is to register the company for VAT once it reaches a certain threshold. There's a substantial amount in there. But what's very interesting here is in one of the few areas in our South African law that actually mention the fact that a director or a person could be firstly held liable from an administrative perspective. In other words, he could get a fine, a penalty, additional interest. He could be found guilty by SARS in that instance. But additionally, they could still face certain criminal actions as well. Now, there is this gray area in the law where it says you cannot be held criminally liable for any financials, for any debt, anything like that. But in certain instances with SARS, you could have a fine. And as they say in America, double jeopardy. You can then, even if not found guilty and no fine, there could still be criminal prosecution. Other way around as well. There could be criminal prosecution. You could be found not guilty, but then you could still be subject to a fine or a penalty in terms of this particular section. Please, ladies and gentlemen, have a look at that and see where we are going with this. Keeping it short this morning, I want to thank you for your time. And just a reminder again that whatever I discuss this morning is my own views. It is my experiences in business rescue. It is how I understand it, and it's not necessarily the same opinion of the associations I belong to or the other entities that I am a part of. Ladies and gentlemen, thank you very much for your time, and I'll see you again next week, Friday.